This is WBSM On Demand.
It's time for South Coast Now with Chris McCarthy. Streaming live on WBSM.com and the WBSM app. Call 508-996-0500. Text us using App Chat on the WBSM app. Now, Chris McCarthy.
Good morning. Boy, it's a beautiful day out there. Make sure you get outside and get some sunshine and get some exercise. Activity is good for you, your heart and the mind and the soul, right? We have my friend Christopher Markey, the representative from Dartmouth and New Bedford here in studio. He's always willing to take questions as his job as a representative. But I brought him in specifically today to talk about the Karen Reed case. As many of you know, Chris was an assistant district attorney in Bristol County, and now he's a practicing defense attorney. And he is not involved in this case at all, okay, on the defense or the prosecution side. So he's speaking as a neutral party, just a knowledgeable person, a very knowledgeable person about the prosecution and defense that goes on in a murder investigation, in murder prosecution. So good morning, Chris, and welcome back.
Good morning. How are you?
I'm doing well. Thank you. This case has caught the national attention, the Karen Reed case. And while obviously there's certain details you're not privy to because you're not on either side, give us your thoughts on this case and what's happening.
Sure. I think one of the things is that I think it's caught the national attention because of a blogger who then got charged with intimidation of a witness.
Right.
So it's really interesting. I think that the theory of the defense has also created a strong interest in it on this grand conspiracy stuff. But I think also the prosecutor has, and again, I'll have a disclaimer that I don't know all the details of all the facts, but so it's difficult to comment, but just generally speaking,
yes.
You don't often see a car accident turn into a second-degree murder. Second-degree murder requires an intent to kill or an intent to cause grievous bodily injury or conduct an act that has all the factors known to an individual. A reasonable person would conclude that there's a strong and plain likelihood that death would result.
Okay.
I don't know if you can get to that point. I mean, the way the prosecutor will try to get to that point, I think, is a lot of the relationship issues that apparently they've had to try to show a motive. They would try to use her statements, there's some, again, sprinkling of statements that have been distributed publicly, one being like, I hit him last night, is he dead, before they even got there. Those types of statements can be helpful to the prosecutor.
Okay.
And then they would go into if they got, I think O'Keefe's children had heard them arguing over the previous series weeks.
Yep.
I don't know if they'd call them. They're very young. I don't know if that's a wise move in the long run.
Okay.
But if it's the linchpin to proving a second-degree murder that there's an intent to kill, then maybe that's it. I just find that unlikely. So I think that the charges have resulted in this idea of, hey, there might be a conspiracy here to really get him. The other thing is he's a police officer. Mm-hmm. Those are cases where, again, I think when police officers are killed and children are killed, there's corners that could be cut.
Okay.
And again, I'm not saying it in a very bad way, but those are the cases in which men who do this job every day, there may be more motivation for it. I'm not
Yeah.
saying that they would be doing it.
Right.
But God, if it was one of my colleagues, I would want to be more interested in the case than anything else.
Yes.
So those things are there. So now the defense is really like this, what they call a third-party culprit.
Yeah, explain that.
So a third-party culprit is someone who the defense would have to create, has a motive, and has the intent, and also the opportunity. And it's a long-standing tradition in Massachusetts case law that you can do this. The problem is you need to be able to do it through admissible evidence
Okay.
and not speculation. And that's where a lot of the difficulties come for defense attorneys in regard to the ability to prove that. Because whatever they produce can't be based on speculation. And it has to be based on admissible evidence. What is admissible evidence? Well, it's evidence that is subject to cross-examination. So hearsay evidence may not come in unless it's an exception to it, whether it be intent or modus operandum or something to that effect. There may be ways to get that state of mind. And then there is the actual idea of it being relevant. And the relevancy is an issue that I think is going to become difficult for them, and be able to make sure that they provide the admissible evidence through non-hearsay to get to the point of saying, okay, there is a legitimate third-party culprit.
Okay. Joe, now I noticed the judge had to give the defense permission to use this. Why is that?
Well, because what you're doing is in all criminal cases, the Commonwealth or the government has the burden of proving the case. The defendant can just sit there and do nothing, not ask a single question, not do anything, and nothing that they do can be used against them by the silence or anything like that. That's the traditional Fifth Amendment. What you're doing here is you're saying someone else could have done it. And the idea is that you need to provide notice of what evidence you're going to provide.
Okay.
And a judge is the gatekeeper of evidence in every case. And she wants to make sure that the evidence that is going to be produced at trial could create a third-party culprit. She's not convinced in this respect that it's enough that she's confident that they should mention it in their opening statement. Okay. So that's all it is right now the judge has ruled kind of denied the motion without prejudice, so that just basically saying, don't mention it in your opening, but if you decide to develop it, you certainly can use it in a closing argument and develop that evidence. So it's a precaution that they do, the same that they would do for a prosecutor. A prosecutor, for example, if it's a guy's, we use it for prior bad acts. The judge is typically not going to allow a prosecutor to put into evidence prior bad acts of an individual to prove the person's intent. Like if I'm caught with a bunch of cocaine on me.
Okay.
And I go, well, it's only for personal use. But on my record, I have 15 distribution charges.
Right.
They can bring those prior bad acts in to show the defendant's intent of why he possessed. So, but judges typically do not allow prosecutors to mention those types of things. So on the borderline pieces of evidence, both sides put in motions in limine prior to a trial and get a judge to try to weed out what's going to come in and what's not going to be coming into evidence, and then use that kind of as a measuring stick as to where the case is going to go, but also to control what is said in an opening statement.
So as we watch this case unfold, we'll be listening for evidence of someone else doing it, right? Is that what you're...
Yeah, that's what they're going to try to prove.
Okay.
But how do you get to that point? They've mentioned it. I think one of the more interesting aspects of the case is going to be the medical examiner's testimony. Okay. I just don't know how. I did see pictures of the autopsy or pieces of it that it just didn't make sense to the type of injury of just getting hit by a car. Now, if a snowplow came and hit him, yeah, that could be some of those injuries, but there may be other ones that are significant. The problem with that is how do you prove it? They're trying to say that a dog may have bitten.
We've heard that, yes, a dog.
And the puncture wounds on his left arm or his right arm. I don't know how the defense is going to be able to establish that.
And if Rin Tin Tin has an alibi, it's out, right?
Then Lassie comes in
Yeah,
and saves
there you
the
go,
day.
right? But the dog bite thing is can the medical examiner, because you've dealt with this a lot, obviously, as a prosecutor and a defense attorney, can they tell the time at which that wound may, or the time around that wound may have happened?
Well, I think they could tell was it post-mortem or pre-mortem. So that would be something that could be developed, I think.
Okay.
But I honestly, I just don't. It's a difficult case for the defense to create the conspiracy theory that they have, because you would have to have a ton of people involved in the conspiracy.
Yes.
And the more people involved in it, the more difficult it is, because the more likely that someone is going to mess up. Mm-hmm. So that's one issue. Then you have like the whole, glorified, I call it kind of BS that comes up with like, all the police are covering for the police and all that. Right. So that plays a role in it, but I don't think it's really difficult. We got to remember that the state police from the district attorney's office ends up handling the matters and not the local police. So there's a lot of talk about the local police being investigated by the FBI and other things. Mm-hmm. Yeah, that's true, but ultimately it's the state police assigned to the district attorney's office that does it. Now, the other question is the district attorney's office playing into the hand of the defense by doing all of this stuff with the blogger and trying to, push them back for that or whatever, and it creates this whole new thing. I just sometimes it's better to ignore that type of stuff.
Yes.
And I don't think that if there's a decision that's been made that I would really question, it would have been with the DA's office on that issue of really pursuing a charge against this guy. Not saying that he didn't do anything, because right. I think there's clearly from videos that I've seen there is a harassment of people. Mm-hmm. But most of them are some relation to law enforcement, and they should have a little thicker skin.
We're speaking with Chris Markey. He's a representative from Dartmouth, state representative from Dartmouth and New Bedford, but he's also a criminal defense attorney and a former assistant prosecutor here in Bristol County. We're going to take a quick break. We'll be right back. If you have a question, it's 508-996-05. We're happy to take your questions here on this topic. Stick around. We'll be right back. Welcome back to the program. I'm joined here in studio by Representative Chris Markey. We're talking about, so Chris is a defense attorney. He was previously an assistant prosecutor here in Bristol County. Talking about the Karen Reed case. The idea that they're going to say it wasn't Karen, it's there are other police officers, right? They're going to accuse cops.
I think that's what they're going to end up trying to say is the property owner whose house it was at. I mean, it's going to be very interesting technical evidence along that line. I think they have some testimony from a forensic, digital forensic person who has the phones that says that at 2:27 or something, 2:32 in the morning, they were looking up how long it takes for a body. But then the Commonwealths say, no, it's 6:32, and it may be whether it's Greenwich Mean Time, okay, or if it's Eastern Standard Time,
really?
Which is an issue with all types of phone records. If you really get into the details of it, I constantly send phone records to an expert to figure out what time these things actually happen.
Really?
Yeah, because if you look at your phone records, not everyone who has a cell phone is in Eastern time zone.
Correct.
So it usually says GMT, which is Greenwich Mean Time.
Okay.
And then depending on what time of year it is, because we go back in our clocks and they don't, it could be 4 hours, it could be 5 hours. So it's crazy, or 5 hours and 6 hours, but it's all these things that are going to make a difference.
Because if you're Googling how long does how long does it take for a person to die in the cold, something like that, and it's 2:00 in the morning. But if you would, and
then someone appears dead in the morning in your front lawn in a snow pile.
Right.
That's a really interesting fact. And then they have puncture wounds and not consistent with what, and then there's also the thing that I don't think people buy into. This is where I think the at least in an objective way, the defense is going to have an issue is I don't think people truly can believe that the police would plant DNA to the degree in which they were able to do it if you believe that there's DNA of the victim on the taillight and pieces of the taillight.
Right.
I find it hard to believe that that's the degree in which they've gone. Now, at that time, you also have to they're looking at it as maybe it was a motor vehicle homicide, right? Just simple motor vehicle homicide. He's in the middle of the road. They're not investigating it like a murder.
Right.
So all of that plays to a degree. They're not going to make up stuff for motor vehicle homicide, right? But the couple of interesting things is that the police never went into that house.
That's interesting.
That's a fact. Again, these are things that I think a common investigation would say, hey, we'll go into that house. Now they've kind of gone over the top where they sold the house. I mean, now the defense is saying, well, they sold the house, they covered the pool, they got rid of the dog. That's when it starts getting a little bit grandiose. Mm-hmm. And I think people have a much more difficult time believing it because there's more participants in that. But there are certain things.
But will they be able to get that in front of the jury?
Well, that's the question. How are they going to do it? And they're going to have some very creative ways to get some of it in, but most of it should come in.
Okay.
But the question is it going to be believed? I mean, the conspiracy thing, the constellation of evidence that has to be aligned to have that really work, it's really, really difficult.
I totally agree with you, Chris, on that. It is a very bizarre case. We're talking about the Karen Reed case going on here in Massachusetts. It has caught the nation's attention. I think the death of John O'Keefe has almost gotten not forgotten, but papered over by all the other things that are going on.
Yeah, I mean that's what's sad about it is I think from my understanding is his wife had passed away. They had 2 kids. Is that right? No, his siblings had passed.
Yes, and he adopted
the kids.
Yeah, I mean he's a good guy from what I understand.
I mean all indications are that and again who they're with. I think once the case starts, you'll start to see how it's going to develop. I mean, I just think in my heart, from everything I said, it might be overcharged.
Right. Let's get back to that. Explain that, because I've thought that from the beginning. I thought, jeepers, I mean, I've had fights with Natalie and other girls over the years, and I'm sure you've had, arguments with your spouse. And if I backed over them, I would never intentionally kill someone. That's not how I would do it.
Well, I think you're speaking too much. You should keep your mouth shut. But beyond that, no, yes. I guess my thing is that first off, if you believe everything the government says, right? She's drunk,
right,
at the time of the offense. So does she have any intent to kill? Will she have a diminished capacity because of alcohol? If you believe their theory,
all right.
So say she's hammered because apparently they think that she has at least a 1. I don't know what it was, a 1.8. So that's over 2 times the legal limit. Does she have the ability to have the intent to kill?
Okay.
Does she have the understanding of all the circumstances around it that there would be a plain and strong likelihood of death?
All right.
And does she have an understanding that the intent to have cause grievous bodily injury? Now, all of those things may be affected by her consumption of alcohol. I don't know, but that's the problem with their case, in my mind.
Okay.
Then you go to a manslaughter OUI, which is wanton and reckless conduct, which you could say, but if she's just doing like a 3-point turn and slams the car back for a second and then doesn't know where he is, thinks
Right.
he's walking into the house,
Right.
okay, then there's really no wanton and reckless conduct. So the next thing is a negligent operation of a motor vehicle that caused the death of another while you're under the influence of liquor, and that seems more in line of it. That's just, again, my humble opinion on kind of the circumstances. Now, if she has statements that says I wanted to kill him or I did it, and
Right.
I don't even think I did it is enough to prove her intent.
Right, because it's
It's
just
post.
Yes, like I made a mistake or whatever. I did it. I'm sorry. I did it. Something
Yeah.
like that. Right.
Yeah.
Do you think, getting back to this, the fact that he's a police officer, do you think, and you touched on this earlier, but that they overcharge because you get to the scene, you knew the guy, you know he's a cop, and now you overcharge?
I don't know. Maybe they thought, okay, well, if we charge her with this, then we can get a plea out of it on something. Okay. I don't know. I honestly, I do have trouble understanding that charge.
Okay.
But I also, on the other hand, do have some trouble understanding the grandiose nature of the conspiracy. So I think it's probably somewhere in the middle.
We have Representative Chris Markey here in the studio talking about the Karen Reed case. Chris, of course, was a former assistant prosecutor here in Bristol County. He's a defense attorney now. If you were handling this case, and again, you don't know all the evidence, certainly, but seems like a real big bank shot. Those cops in the house killed him over my client unintentionally backed over her boyfriend after having too many drinks.
Yeah, there's a significant difference.
Yes.
And the consequences are very significant. One is second degree is life sentence with a possibility of parole in 15 years. The other one, the OUI, motor vehicle homicide, negligent operation, is a 1-year minimum mandatory. So there's a big difference between 1 year and 15,
yes,
and then being on parole for the rest of your life. So there's that significant difference. But I think that they're looking to create a reasonable doubt.
Yes.
So if they can buy into portions of the conspiracy, maybe they can. But I think you're all in or you're all out on that. I really do.
Yes.
Because I think the argument is pretty simple. That, you would have to believe, if I was the prosecutor,
right,
you would have to believe this person, this person, this person, this person, all the way through to the point of,
I believe there are firemen. I believe there are police, state police, all
federal agents
that are put into this conspiracy, if it's to have worked.
Yeah. And I think that they're, again, having it in your mind and talking about it like us on the radio
right,
is one thing.
Yes.
Or talking about it on Facebook or wherever, it's one thing. To actually have the admissible evidence, and again, having it in a convincing way, and then also understanding who those witnesses are that you will have to call, who will be professional witnesses.
Yes, because they're all trained to testify.
Yeah. So it's a big, huge hurdle to overcome.
What if, Chris Markey, they opt to take the Fifth Amendment and don't get on the stand? Is that a problem for the prosecutor or the defense, or both?
Well, I think it's going to be a problem for the prosecutor that they don't testify. And that's another issue and it's also a problem with their professional.
Can you compel them?
The defense cannot.
The defense can't, but the state.
Yeah, the state can give them immunity. But some of these people apparently on federal problems, so they would want federal immunity as well. Okay. So I mean, they could easily get up and plead the fifth, and then the ability to get that conspiracy evidence in may be a problem.
So that'd be a problem for the defense.
Yeah.
So if these this group of police, both federal and local,
You can't call a witness, you can't call a witness. It's not like TV. You can't call a witness just for them to plead the fifth in front of a jury. They're just not available.
Okay.
So that's a problem.
So if they alert the defense that they're going to take the fifth, they can't call them.
They cannot. They can call them outside the presence of a jury, figure out what they're going to do, and then make that determination.
But the jury will never hear them take the fifth.
Yeah, they'll be in the newspaper, but
And they'll probably lose their job.
that's the other part about it.
Right.
Right? A federal agent pleading the fifth on a case, which is a murder case of a police officer.
Right.
And then they're all being investigated in some fashion. And again, the investigation, we don't know what the degree of the investigation is. Is it even related to this case?
Right.
And, that's their own, there are going to be problems with it.
So the police officers who own that home, they're likely going to be called, right? You're saying?
Yeah, I would assume that they're witnesses.
Yes. So who would call them, or both would call them?
Well, that's an interesting, like if I'm the prosecutor, I want to, we used to say, get in and get out,
Okay.
right? Get the evidence you need to make the argument, and then get out and don't do anything. If you don't need them, then don't put them up there.
Okay.
If you can prove it through somebody else, then don't put them up. And what does that do? It requires then the defense to present them, and it's their witness. They would have to use direct examination rules, which would be non-leading questions unless they're determined to be hostile. But then as a prosecutor, you get to cross-examine those witnesses on issues in which you get to lead them. So strategically, you may want to be able to have them on cross rather than direct.
508-996-05. If you want to get on the conversation, you can. So what do you make of the fact that these police officers at the house, who they were there as social friends and colleagues of Mr. O'Keefe, they weren't there in their official capacity, they have, and other family members, have hired defense attorneys. Does that get brought into the case, or is that not admissible? How does that work?
It's going to be interesting. I don't know how that the fact that they have lawyers doesn't mean anything.
I would have one if I was them.
And I think one could say that in light of what was going on in the blogging world, that they needed a lawyer, and they wanted those things, and they knew that if whatever they produced as evidence at a hearing could be subject to being placed onto Facebook and other things.
Okay.
So that may have required them to say, hey, I want a lawyer to figure these things out.
Yep.
Which makes sense.
Yes.
I mean, that there's a lot of things that have been posted and other things that people don't want on in a public forum.
Right.
So that may be a reason why they got lawyers, and it may be more criminal, but I don't know about that. But there's legitimate reasons why you would get a lawyer.
No, I totally agree with you, particularly when you think about how much they've gone into these witnesses' privacy, right? Which maybe is the normal case, but we just don't realize it.
I'm worried about that.
Okay. Explain it.
Traditionally, we all want an open hearing, right? We want an open trial. We want witnesses to be subject to cross-examination. We want people to know who the witnesses are, all of those things. I'm troubled by the degree in which they went to expose witnesses in their private life, going to a soccer game or a lacrosse game and getting kind of in their face and saying things to them and provoking them. That's not what it is meant when we have an open hearing and a public hearing.
Right.
But what their reputation and those things prior to their statements are all relevant to the case. Mm-hmm. But you can't provoke it and get in someone's face to be able to get to that point. Now, do I agree that the provocation is to a degree of intimidation? It might not. It's a close call. to even get to the point of even presenting it to a jury. But I still think that most of the people who are the alleged victims of the intimidation have some relationship to law enforcement, whether it be a spouse or the officers themselves. Or that's where I'm like, hey, it's one thing to be a little old lady and it happened. It's another thing to be a police officer, and that's kind of the gig. Right. I don't want to, but I'm worried that if this continues, what's going to happen in the future for police officers, even for witnesses, particularly police officers? Are these people going to stalk these police officers? And it's got to come to a stop.
Yes.
It can't be to the degree in which it is. And that's where I have a lot of sympathy for the witnesses and the police in this particular circumstance. But on the other hand, is it necessary to do it to the degree that they've been doing it?
And the spouses, my understanding, and again, I don't know anything more than what's in the public domain, but the spouses taking to social media and commenting on things, not necessarily the case, but the characters involved in the case, it really has gotten out of control, right? That's not normal, right?
No, it's almost like a Saturday Night Live skit.
Exactly. It's not normal.
Yeah. No, it's not. It's something that, if you're a witness, you hope, no matter what side I was on, you're always got to be disciplined and understand the consequences on both sides. Whatever you say, whatever you post on social media is in the hands of the other side.
Right.
So act appropriately.
508-996-05. We're going to take a quick break. We have Representative Christopher Markey here in studio. He is here, he's always here as a representative, but he is here talking about his time as a prosecutor and currently a defense attorney in Bristol County. And we're talking about the Karen Reed case. He's giving us his expertise without any specific knowledge that's not in the public domain about the case, just his experience as a prosecutor and a defense attorney. If you want to get involved, you can. 508-996-05. Stick around. We'll be right back.
Seasons don't fear the reaper, nor do the wind, the sun, or the rain. We can be like they are. Come on, baby, don't feel the reaper. Baby, take my hand. Don't feel the reaper. We'll be able to fly. Don't feel the reaper. Baby, I'm your man.
Welcome back to the program. Beautiful day out there. Great day to go. Bring your car to get serviced or to look for a new car. Mac Auto Sales, 188 Rivet Street, New Bedford. The sun is shining down there on Rivet Street today. They repair all makes and models. So if you need to get your car ready for the summer, and you do, call Mac Auto Sales and Repair. 508-565-6221. They're open for your convenience weekdays 9 to 5. Now, if you have a foreign car that needs repair, Mac Auto Sales specializes in foreign car servicing. Ask about their aftermarket accessories and their quality used cars that they have for sale. Mac Auto Sales, 188 River Street, New Bedford. Tell them Chris McCarthy sent you. So, how long do you think this trial is going to take, Chris?
I assume they're going to go full days. I'm sure there'll be breaks for a day or so here and there, or afternoons. I would probably think it's going to be at a minimum a month and a half to 2 months, maybe 2.5 months.
Will they sequester the jury?
No, not until maybe deliberations. I don't know. Maybe at that point they would. But unless something happens, I think that's fluid, but I don't see any reason for it. I know the defense made a motion on Friday, I think, about the composition of the jury, saying from Norfolk County and looking for a change of venue. That's not going to happen, and it's just one more protection of the defendant's rights if they want to appeal, something to that effect.
So explain that.
So they could say that the trial is has so much publicity, and there's connections because it's as much as we think our world is huge, it's still small Norfolk County.
Yes.
That they can't get a fair jury.
But you have to raise it now?
Yeah, you would have to raise it now
and
say that. There's this case doesn't bring in race, which is something that the courts look to in a great degree, is making sure if this was a black victim, white defendant, or vice versa, there are safeguards to be able to exclude people of color or certain classes of people who are protected classes, women, elderly,
handicapped people like me.
Yeah, that they would all have. They have special protection, so you need to make sure that those jurors' rights are protected as well as the rights of the individual.
508-996-0500. What do you make of the Turtle Boy arrest and all of that? He is the blogger that's involved in this. We've never seen that before, but of course we've never had this kind of I wouldn't call it renegade, but non-editorial, non-corporate media.
Yeah, that's what I was speaking of earlier. I'm concerned about it in the long run. That how far can you go to be able to do this? And I am troubled by it a lot, just for the safety of the system. But what happens on a regular run-of-the-mill case that all of a sudden some kid has an interest because his buddy has been charged with murder?
Okay.
In New Bedford, just say.
Yes. And
then all of a sudden they stop posting everything about this person and that person, and there's no, you don't know how truthful it is.
Right.
And I have found at least that there's, when you start to deal with the blogging sphere, that there's less safeguards for publishing the truth.
Yes.
And it becomes more and more difficult. And the other part about it is, so what, right? So the Turtle Boy says this stuff. You want to sue him for defamation if he's not telling the truth. What are you going to get from him?
Right.
Right. The idea of fundamental corporate type media is you could sue him for defamation and there's money behind it.
Yes.
Look at Fox News, got jammed up big time.
Big time.
But on this, how do you do it? So I don't know.
508-996-0500. I got a couple of people on hold. Good morning. Thanks for calling.
Good morning. So one of my problems with a lot of this information, if you watch, court TV, they have video of when Karen Reed went back to look for him. She makes a 3-point turn in their driveway or whatever, and they have video of that. Now, these are police, and they're all family and all connected. It was a small group of people. It wasn't like a bunch. I don't think it was a lot of friends, because it was the homeowner's sister-in-law that invited him, and supposedly his nephew was there that the victim had beef with in the past, whatever. But why don't they have video of when she dropped him off? Why is the video there of her coming to see it? He's a police officer. If she's going to look for him in the driveway, I would think that's because that's where she dropped him off. And there's no video of her going there and dropping him off, but there's video of her looking for him. If he's a cop and he's got cameras outside, he must have them on every angle of his house.
Well, see, that's part.
Thanks for the call.
Part of the problem is we don't know what the evidence is. I don't know. I mean, I know a lot of police officers, and I don't think they have lots of cameras on their houses at different angles. They may have a Ring camera, and the Ring camera can pick up certain things in certain locations, but it's stationary, and you probably don't have the ability to get a great view of things. But that's part of the problem with all of this is speculation is, they should have had this, they should have had that. And
right.
That's the dangers of it, and we'll find out the facts over the next 6 to 8 weeks when the trial's going forward. And but until then, I don't think we can really comment on why that wasn't there. There may be a legitimate reason for that. And there may not be, but it's going to be decided by 12 people who figure out if the reason why there is no camera of a particular time is based on believable evidence. And until that, we really can't comment on why that certain things happened and certain things didn't. It's just got to develop.
What I have found with a lot of conspiracies is that the lack of evidence is, in some people's mind, evidence. Right? That if there's no evidence, that must mean that it is a conspiracy.
Well, this is, it's very funny you say that because I had a murder case where we did DNA, and we had to do DNA to prove that there was no DNA.
Okay.
There was a fingerprint on a gun, and it was a partial fingerprint, but we could not. There wasn't enough there to make a determination on DNA. But if we didn't do it, right? If we didn't test for DNA,
right,
they would be able to argue, hey, they had a chance to do DNA and they didn't do it.
That's a good point.
So you have to almost prove a negative through doing that. And that's one of the things that's going to make it difficult for the prosecution in this case, is because there are so many things that that the defense is saying that creates this conspiracy. You have to show that it's not only that she did it, but it's not this conspiracy. And a lot of the evidence for the case will be to try to corroborate everything that they've presented in their case.
508-9960. We're going to take a quick break. We'll be right back.